Hello, my name's Olu Osha. I've been talking about American presidents, which I like talking about, and I've also been talking about the era of the Cold Wars, our presidents during the Cold War, and I've been discussing the situation of the authoritarian regime in the USSR. However, I thought I should, just sort of segue and highlight an era of the US presidencies when we've actually had dictatorship, right? We've had an authoritarian rule. And yes, we've had presidents who've constitutionally, right, constitutionally, legally exercised dictatorial powers. And I'm going to be discussing my favorite president, not everybody's favorite president, but he's routinely ranked the number one U.S. president, the best president we've ever had, and that's Abraham Lincoln. He's actually exercised dictatorial powers, but legally, right? So in our Constitution, emergency powers are granted to the U.S. president temporarily and only in a case of an emergency, right? So that's why it's called an emergency power, right? So they're granted in, for instance, Article 1 of Section 9, Clause 2. The president is actually given powers to suspend habeas corpus, the government, right? So it's understood that it's Congress who grants the president this right, this authority to suspend habeas corpus, right? Habeas corpus is Latin, and it's short for habeas corpus means produce the body, but it's short for habeas corpus ad subjiciendum, right? Habeas corpus ad subjiciendum. It's Latin, and it literally means you shall produce the body to be subjected to examination. So it's being understood that you're producing a body to a court, a neutral judge. So it prevents and we call it habeas corpus. Legal scholars have called it the most powerful tool in the rule of law. It's the most powerful rule of law. It's and it prevents the government from detaining anyone, not just citizens, anyone within U.S. jurisdiction arbitrarily. It prevents wrongful imprisonment without a legal cause. So if anybody has been arrested, they have a right to appear before a neutral judge to question the legality of their detention. The idea is it prevents persons from being disappeared, right? From being disappeared by the government without a public reason, which happens. This happens in authoritarian regimes, and I've talked about how this was common in Stalin's USSR, and not just Stalin's USSR, but in the Soviet Union generally and other authoritarian states. I'm originally from Nigeria, and of course, this happened a lot during military dictatorships in Nigeria. People are taken away, they're disappeared for state reasons without a public reason, and they can be tortured and they can be killed, right? And then the government can now produce an official reason and claim that, well, the person went crazy and attacked them, and so they had to kill him, or so whatever, things like that. And so in America, in a free society, we don't want that, right? We don't want that to happen. So it happens in a police state, right? A police state like the USSR. And I wanted to, because I've been talking about the Cold War and what was going on, and I wanted to be able to highlight the differences, but it would not be fair. We would not understand our government better if we don't point out that we do have instances when this can be done, and it has happened in our history. It's actually lawful. It's in the U.S. Constitution. Again, it's in Article 1, Section 9, Clause 2. It gives the government the right, habeas corpus is guaranteed to individuals except in cases of a rebellion or an invasion and where public safety is required, if it requires public safety, right? So those are the rare instances when habeas corpus can be suspended. That power is granted only by Congress to the U.S. president. But we find that Abraham Lincoln, he exercised these powers during the Civil War, right? So during an invasion, during a rebellion, of course, there was a rebellion, insurrection of the southern states, the slaveholding states who were trying to secede. So that was why Abraham Lincoln exercised that authority. And again, I've talked about how our founding fathers, the framers, really they copied the Roman Empire, the Roman states, right? In terms of how our government was structured and designed, the architecture of our government. Remember, our framers were students of the classics. So I've mentioned how James Madison, a student of the classics, he literally studied the classics, and James Madison, we call him the father of our Constitution, the author of the Bill of Rights. For him, the most important constitutional right was, he called it conscience. He said conscience is the most sacred of all property. For him, that was the freedom of conscience. So the government should not impinge on this, and so that was why he gave us the First Amendment in the Bill of Rights, and so which gives us freedom of expression, and it imbibes the freedom of thought, conscience, and our beliefs. It separates the church and the state. So that was James Madison's most important right. He said conscience is the most sacred of all property. However, my favorite founding father, Alexander Hamilton, for him, habeas corpus, right? He said habeas corpus was the most important for him. He said habeas corpus is the greatest security to liberty and republicanism, right? It was about the greatest security to liberty and republicanism, even than virtually any other constitutional provision. And that was Alexander Hamilton's, those were his own thoughts. Habeas corpus was fundamental. It was virtually the greatest security to liberty and republicanism. That's habeas corpus, right? And so, and as I was saying that, our founding fathers really copied the classics. They read the classics, and they were really looking to the Roman state as a model. And I figure that they were probably looking to the story of a Roman statesman and farmer named named Lucius Quinctius Cincinnatus, right? So in the 5th century BC, the Roman Senate were said to have, 5th century BC, that was the era of the Republic. Now, I've mentioned before in earlier videos that, the Rome was actually divided into 3 eras. The first era was, the first era was the era of the regal period. They had kings. They did away with the kings, and then they now had the period of the Republic, the Roman Republic, and that was sandwiched in between the regal period and then eventually the era of the emperors, right? Starting with Augustus Caesar in 27 BC. So from 529 BC to 27 BC was the era of the Republic. They didn't have any emperors, they didn't have any kings. They had the Republic, right? And it was a rule of the senators, right? So in the 5th century BC, Rome was invaded, right? They were invaded by an army, and so the Romans, who hated kings, now their Senate appointed Cincinnatus, who was a statesman and a farmer. They appointed him a dictator, and they gave him supreme authority so that he could raise an army and defeat the foreign invaders, which he did successfully. So he raised an army. He defeated the foreign invaders, freed the consuls, and secured the safety of the Roman Republic. And after he did that, though, he held the dictatorship for just 16 days. So he resigned his dictatorship and returned to his plow as a humble farmer. And so he's really lauded and praised by the Romans as a model of virtue, as a model of virtue, the ideal Roman citizen, right? So he didn't show any personal ambition. He had complete self-interest. His focus was on public service and the common good, and he wasn't seeking the accumulation of power. He wasn't seeking his own self-aggrandizement. So he returns to his farm. Now, a second time this happens, there's a rebellion, right? A rebellion of the plebeians, right? The plebeians class were the commoners, right? They were the commoners in the society. So there was a plebeian insurrection. They called Cincinnatus again, and Cincinnatus again raises an army, and he puts down the insurrection. And again, he retires. He resigns his dictatorship, his absolute power. He's an absolute dictator. He resigns it, returns again to his farm. So he's praised as a model of virtue. In fact, George Washington, because he only had 2 terms, he's called the American Cincinnatus, right? So people wanted to make George Washington a king. They wanted to give him. There were framers who sought to give him life tenure, like Alexander Hamilton, John Adams. They thought he should have life tenure, but after 2 terms, he resigned, right? After 2 terms, he retired, and he set the standard, right? It was the standard that, our presidents would not serve more than 2 terms. It was an unspoken, it was an unwritten, unstated, unwritten custom that, the U.S. president would only have 2 terms, until, of course, we had FDR, who had 4 terms. And after that, it was enshrined in our Constitution, the 22nd Amendment, that the U.S. president would not have more than 2 terms in office, right? He would not serve more than 2 terms in office. An aggregate of 10 years. I've done a video in which I explained that, so I'm not going to get into that. I don't want to digress. So Cincinnatus was very important to our framers. In fact, after the Revolutionary War, a society of Cincinnati was created for the Revolutionary War veterans, and they gave them, it was a life hereditary thing. George Washington was the first president, and Alexander Hamilton was also president general after George Washington. So you can see that America modeled, they looked to Rome and Cincinnatus, life in framing our Constitution and our government, right? So Cincinnati, Ohio is named after Cincinnatus. So that's the idea of giving our president emergency powers in the Constitution. So it's constitutional, but it's temporary. And, the idea is that our president would also model the humility and lack of self-interest, lack of personal ambition, prioritizing the common good and public service, and it would be totally disinterested, in accumulating personal power, and that he would resign this dictatorial powers that he's been granted by Congress, once the emergency has been quelled. So during the Civil War, Abraham Lincoln, however, he did suspend habeas corpus, in April 1861 in the state of Maryland, and of course his reason was that because there were threats made against the federal troops in Maryland, and so he also wanted to make sure that there was no obstruction of federal troops and the supply lines between Washington D.C. and Philadelphia. So he suspended habeas corpus. Which meant that the government could detain people without, indefinitely without a trial, right? And so that violates, our constitutional rights. It violates due process of law. That's the Fifth Amendment, and so it violates, your right, your right to be free from detention without cause. So uh, he did this, however, in 1861. He did it originally without the approval of Congress. Again, it's Congress who's supposed to authorize it. And this happened in Maryland. And of course, Chief Justice Taney, who was from Maryland. Of course, he was the Chief Justice of the Supreme Court. He was the one who, of course, wrote the opinion, decided the dreadful Dred Scott decision that said U.S. African Americans were not U.S. citizens. They could not sue in court and things like that. So he was now complaining that what Lincoln did was unconstitutional because he was not authorized by Congress. Lincoln, who was a brilliant attorney himself, he argued that, he did it because Congress was not in session. They were not sitting, and there was an emergency, and that's why he authorized it. He suspended habeas corpus. And fortunately for him, though, when Congress did eventually sit, they did indemnify Lincoln. And in fact, eventually, they did pass what was called the Habeas Corpus Suspension Act in 1863. So, he expand. So initially, when he suspended habeas corpus, that was only in Maryland, right? So it gave him the authority to detain citizens without, indefinitely, without appearing in court, right? So they could just detain people, and the objective was to detain prisoners of war, people who were spies. But how do you determine if somebody is a spy? So it just means arbitrarily the government can just pick up anybody and call them a spy. How did they determine somebody is a spy, right? So that typically we have a right to a public trial. So he had the right to just detain prisoners of war, people in the military, spies. And then eventually in September 1861, he expanded it to all states to include anybody who was interfering with the war efforts or Confederate sympathizers. Confederate sympathizers were called Copperheads. And so, again, in 1863, Congress now passed the Habeas Corpus Suspension Act. Interestingly, there was a guy who was called, he was a Copperhead, right? The Copperheads were also, Democrats who, they were called peace Democrats. They opposed the Civil War. They thought that, okay, look, the states should be able to settle this matter, of the slaves and everything peacefully, but there was this guy. He was a Copperhead, and he was a Confederate sympathizer. His name was Lambden P. Milligan, who was actually a lawyer and farmer in Indiana. So he was arrested in October 5, 1864. The charge was that under the Suspension of Habeas Corpus Act, he was accused of conspiring with 4 others to steal arms and invade a prisoner of war camp and release Confederate prisoners. So he was subjected to a military tribunal, and he was sentenced to death by hanging. However, there was a habeas corpus appeal that eventually, that went from the Indianapolis circuit all the way to the Supreme Court, and it's called Ex parte Milligan, and eventually the Supreme Court ruled that, the habeas corpus act in itself does not give it doesn't give the government the right to a trial by military tribunal. So they deemed it to be unconstitutional. They said that, that citizens cannot be subjected to a military tribunal when civil courts are open and operational. So they deemed the tribunal, which we sentenced Lambden P. Milligan to death unconstitutional, and so they revoked it. They reversed they voided the verdict. So eventually was released in 1866. By that time, of course, the war was over. He was released. So Lambden P. Milligan eventually would file a suit, and in 1871, he would file a suit for his military arrest and detention, and he would win. He would win, and he was awarded damages for just $5, though, because federal and state statutes limited the amount of damages he could recover. So you see, this is the difference between a free society, which Alexander Hamilton talked about, and a police state, right? A police state like in the USSR, they could just where there's no habeas corpus, right? They could arrest people arbitrarily. The government can arrest people arbitrarily and disappear them into a secret dungeon, right? And and you don't appear before a court, a neutral judge, and so that's like a bill of attainder, and then they can just subject you to a military tribunal and execute you in secret, just like Beria, right? Lavrenti Beria was the head of the secret police, and what he had been doing to people, eventually he was subjected to it by Nikita Khrushchev. Nikita Khrushchev, it said he probably was the one who authorized the assassination of JFK. Nikita Khrushchev was the leader of the USSR at the time of the assassination of JFK. So you can see that these disappearances where habeas corpus did not exist in police states like Russia occurred, and because in a military tribunal it's secret. In a secret trial, nobody's saying what's really going on, and they can have an official version of what happened after you've been executed. In fact, in the USSR, one of the things that they were doing was, if you were protesting against the government, they could arrest you and then lock you up in a psychiatric institution and say you're insane, and they start to treat you, force inject you until you stop resisting the government. And we don't have this. We have a free society in America, and you have a right to a habeas corpus. Now, my rights to habeas corpus, I was detained wrongfully. I've been talking about how I've been detained wrongfully in the state of Maryland to obstruct justice by Judge James Bonifant and Judge B.B. Berry. Of course, they used an emergency. Remember, they used an emergency, but they're not supposed to fabricate emergencies. So with an emergency evaluation petition, this Judge B.B. Berry, she authorized a fabricated emergency evaluation petition by Jide Iware to detain me, remove me, for the police to assault me. The idea was that I was mentally ill and dangerous, threatening. There was no evidence of this. My mother, my family, nobody had it. Well, this was just a state version, right? And so they did all of this, locked me up, and then they wanted to, and then Judge Bonifant would execute false incompetency to stand trial orders, right, to just prevent me from being able to be free from detention and exercise my rights. So fortunately, there's habeas corpus. Eventually, I had to be produced, before courts. But in the meantime, while we're supposed to be free and these legal provisions, these legal safeguards are there, I found in the state of Maryland, and they should be investigated by the Department of Justice. I find the judges in Montgomery County Circuit Court in the state of Maryland who use fabrications, right? They use fabrications, abusive process, and fabricated documents, fabricated petitions, fabricated incompetence to stand trial orders, right? To detain people in psychiatric hospitals, in jail. So these are illegalities that are going on in the state of Maryland, and Judge Bonifant should be held accountable, and Judge B.B. Berry as well, because this has been my experience. So I wanted to highlight the safeguards, the constitutional protections we have in terms of rid of habeas corpus. And as Alexander Hamilton said, it is that there's no greater security to liberty and republicanism, to be found in any other constitutional provision. It's about the greatest security to liberty and republicanism. That's habeas corpus, the writ of habeas corpus, according to Alexander Hamilton. And we find that again it distinguishes us from as a free society, as opposed to police states in authoritarian regimes. And we're finding that the abuse of habeas corpus is going on in Montgomery County, Maryland, where law enforcement and corrupt judges like Judge James Bonifant, Judge Bibi Berry, they are committing fraud on the court, and they're falsifying petitions, emergency petitions, evaluation petitions, and they're also committing fraud on the court in terms of competency to stand trial, in order to coerce individuals and to actually violate, the right to violate arbitrary imprisonment. That's what habeas corpus is there for. It prevents arbitrary imprisonment by the government without legal cause. So you have the right to question the government, to speak in court. But if a judge is saying, well, you're mentally ill or you can't talk in court, you can't defend yourself, right? So these are the fraudulent mechanisms that they're using, devices that they're using in Montgomery County, the state of Maryland's corrupt legal apparatus, right? They're acting like USSR apparatchiks. That's exactly what's going on in Montgomery County. I think they've been co-opted by the military-industrial complex that, President Eisenhower warned us against. Because, I had filed a complaint, living a normal life. I don't have a mental illness. I was not experiencing anything. You can see I've been doing videos. None of my friends, none of my family, not my aunt who's a psychiatrist, nobody's seen it, not my mother, nobody. Just the state making these false accusations, just the way state actors, the government, making these false accusations the way USSR dictators would do. Like Stalin. Stalin would just they would fabricate things and say, well, somebody made a threat, and they'd give that version for killing someone, behind closed doors. In our system, you can't be disappeared into a secret dungeon, right, without a public cause, and then you have a right to a public trial for people to be able to see things. So if they're saying somebody, for instance, is mentally ill, because it's a public thing, right? Because if somebody's acting up like doing things that shows that they're mentally ill, and it's public, it's the public that can see it, then the means to treat them should also be public. You don't take them to a secret place, because when you take them to a mental institution, it's hidden, and the idea is that it's private. No, if you're going to use a public mechanism, right, to hold them against their will, to use duress, then you have to treat them publicly as well. That's what should go on in a free society. So this is a law that I guess is something that I realize I can use my legal skills for in the future. By God's grace, I'm going to take the bar exam, and then I can use this and address it. Help to advocate and champion this cause that minorities, especially marginalized people, should not be removed. Any American should not be removed from public view, to be taken to a secret dungeon, to a psychiatric institution, and where crooked doctors are making false pronouncements, dubious pronouncements, without the scrutiny of the public, of their family. They can be disappeared. They can be treated fake. They can give them fake treatments for a fake illness that they don't have, violating their rights. So if they're going to use an emergency evaluation petition, violating people's rights, then they have to treat them publicly as well, right? They have to treat them publicly to make sure that the safeguards to liberty, fundamental liberty, the freedom of conscience, they're not violated. Because remember, not everybody even believes, for instance, in psychiatry, right? My religion, I don't believe in psychiatry, for instance. I guess there are people who are ill who need these things. but my religion, my faith, my culture, we don't believe in psychiatry, right? So, and that's protected, our beliefs, our conscience, that's protected in James Madison's First Amendment, right? We have a freedom of thought, conscience, and opinion, right? So so we still have these constitutional safeguards. But anyway, I digress, and let me focus on habeas corpus. But it's also tied with habeas corpus because it's a form of arbitrary detention, and habeas corpus is supposed to prevent arbitrary detention. So we see a case where a great president exercised what we can call dictatorial powers, which was constitutional. It's actually constitution. It's in our Constitution, Article 1, Section 2, Article 1, Section 9. Article 1, Section 9. It's in Clause 2, and it guarantees habeas corpus except in a time of rebellion or invasion, and where it requires public safety. So, and Abraham Lincoln did suspend habeas corpus in 1861, April 61, during the Civil War. In September, he expanded it to all states. He started first in the state of Maryland. He expanded it to all states in September 1861, and then Congress passed the Habeas Corpus Suspension Act in 1863. And I talked about the case of Lambden P. Milligan, the lawyer from Indiana, who was a Copperhead. He was a Confederate sympathizer. He thought that the states were sovereign and they had a right to secede. And of course, he was arrested under the act that suspended habeas corpus, and he was subjected to a military trial by military tribunal. He was sentenced to death by hanging. Fortunately, there was a habeas corpus appeal ex parte Milligan, and it's a landmark case. And the U.S. Supreme Court said that the right to suspend habeas corpus does not confer it doesn't give the government the ability to trial by military tribunal, right? Especially where there are civil courts are open and operational. And so it said that the conviction by military tribunal of Lambden P. Milligan was unconstitutional, and it voided the sentence, the verdict. In any case, Lambden Milligan would live longer than, of course, Abraham Lincoln. Unfortunately, was assassinated by John Wilkes Booth in 1865. Lambden Milligan would die at the age of 87 in 1899. So he lived all the way to be 87 years old. He lived, all the way to 1899. I've given this instance. We've had other instances, by the way, when presidents exercise dictatorial powers. There's also the time of FDR, Franklin Delano Roosevelt, when he I'll talk about that, with the internment of Japanese during the Second World War. After Pearl Harbor was attacked, was bombed, was attacked by the Japanese in 1941, December 1941, and so around in February 19, 1942, FDR issued an executive order. I think it was Executive Order 9066, which don't quote me on that. I'll do a video and talk about that. This video has gotten long. In any event, he authorized the removal of Japanese Americans, about 120,000 of them, and they were placed in concentration camps. Interestingly, there was a guy called Fred Korematsu who refused to be removed to a concentration camp, and he did things that were interesting, and it became it's a very significant case that's been studied in law school. We always study it in law school. It's Korematsu. It's called Korematsu, and so I'll talk about what happened in that situation. It's another situation where U.S. presidents exercised dictatorial powers. My name is Olu Osha. I like talking about American presidents, and today I was just talking about a time when my favorite president, Abraham Lincoln, suspended habeas corpus, the writ of habeas corpus during the Civil War, and of course that was him exercising dictatorial powers. Now there were many things. One thing I didn't mention was Abraham Lincoln was able to do this in any event because he had Congress behind him. The Republicans dominated both houses of Congress, the Senate and the House of Representatives. And so apart from supporting Lincoln in the suspension of habeas corpus, which is a very, very powerful, it's called the most important tool in the rule of law. But there were other significant legislation that Abraham Lincoln was able to pass with the support of his Republican-controlled Congress. Of course, the Emancipation Proclamation, the 13th Amendment, was passed with the support of, there was Thaddeus Stevens, and there were Republicans. There were the radical Republicans that were behind Abraham Lincoln and Charles Sumner. They wanted the immediate emancipation of the black slaves and the immediate exercise of their rights as U.S. citizens to actually achieve full citizenship rights. And of course, later on, these came about through what are called the Reconstruction Amendments, the 13th, 14th, and 15th Amendments. Abraham Lincoln passed a lot of significant legislation. The Homestead Act, because he had Republicans dominated Congress. They passed the Homestead Act. He was able to pass the Homestead Act, the Pacific Railway Act, which built the transcontinental railroads. He raised the first military draft, the first income tax, right? Income tax became constitutional with the 16th Amendment passed in 1913 under Woodrow Wilson. But in order to execute the Civil War, Abraham Lincoln was able to institute the first income tax, during the Civil War, during his administration. So many things, he accomplished many things. I've mentioned the Homestead Act, just because he also had a Republican Congress. So you can see how a president can have sort of absolute authority, right? Absolute authority, power with when he has the Congress is made up of, his party dominates Congress, right? His party dominates Congress, just like Abraham Lincoln. He was a Republican president, and Congress, the Republicans dominated the House of Representatives and the Senate as well. So he passed a lot of legislation, and he also exercised dictatorial powers through the suspension of habeas corpus, right? He had emergency powers. Again, it's temporary. The idea is that our president is like Cincinnatus, the Roman statesman and farmer Cincinnatus, who was disinterested. He was just focused on public service and the common good, and he would resign his dictatorial powers after the emergency situation has been curtailed, has been vanquished. Cincinnati in Rome, he had 2 instances where he was granted supreme authority, dictatorial, to be a dictator by the Roman Senate, and both times, after he conquered an invading army and he suppressed the rebellion, he retired back he relinquished his dictatorial power and he retired back to his plow. And so you can see the instances where our Constitution grants the suspension of habeas corpus in Article 1, Section 9, Clause 2, in the case of a rebellion, right, and an invasion, right? And you see, just like, as it happened in Rome, right, Cincinnatus, right, he, the first time when he exercised, his dictatorial power that he was granted by the Senate was during the invasion of a foreign army, and the second time when the plebeian had a rebellion, right? So, and that's how we have it in our Constitution, because we copied the Romans, right? Because our framers were lovers of and students of the classics. In any event, this video, it's time to end it. My name is Olu Osha, and I'll keep you posted. Thank you.